Hello, Renava Rucker, and today I will be talking about Campaign for Fiscal Equity, Inc. versus New York. I will refer to the plaintiffs as CFE. What was the case about? Well, the CFE had two separate cases. The first case was litigated in the lower courts of appeals, where CFE argued that the New York State schools financing strategy shortchanged students in the city's low-income areas, which deprives them of a sound basic education. The plaintiffs said the school district was in direct violation of the education article of the state's constitution, claiming that withholding finances from schools in lower-income communities was racially discriminating against the students because most of the children were predominantly minorities. In addition, the CFE also made a federal claim and sued New York School District under the Department of Education's implementing regulations for Title VI of the Civil Rights Act of 1964. They claimed the lack of funding caused race-based injury to minority children living in low-income areas because they were being educated in buildings that were filthy, unsanitized, dilapidated, unsafe, housed rats, mice, roaches, had no updated textbooks, no school supplies, few certified teachers, and no food programs or resources like the schools within the same district, but in wealthy communities. Well, the Court of Appeals denied the Title VI claims, so the CFE took it to the Supreme Court. In both cases, the Supreme Court required the CFE to prove the intentional discrimination set by the school district. However, New York based the argument of the case on a matter of adequacy, saying the Title VI implementing regulations prohibits policies that disproportionately harm minority students, and that cannot be educationally justified. To support the CFE's claim, they produced evidence showing that in recent years, New York City has educated 37% of the students, but the students in the low-income areas received only 34 to 35% of the state's aid for education. This results in being underfunded by $400 million each year. This 2% shortage impacts minority children because the state's funding formula causes schools to be underfunded, overcrowded, with inadequate supplies, and too many uncertified teachers. The CFE says this violates the Civil Rights Act's regulations by treating minority students poorly relative to their wealthy counterparts. When was it tried? In 1993, both the cases went to lower court of appeals, but then the Title VI was denied and went to Supreme Court under Judge William Rehnquist in 1994, and that lasted until 2006. The decision as it moved through the lower courts to the Supreme Court was the previous Levittown case in 1982, held in the Court of Appeals, saying that the education article makes no reference to any requirement that education be equal or substantially equivalent in every district. The court concluded that as long as children in New York State were getting a sound basic education, and in the absence of some gross and glaring inadequacies in the state education system, it was inappropriate for it to alter the state's school financing strategy. Who was involved in the case? Of course, New York City School District and the Board of Education, but the case was founded in 1993 by attorneys Robert Jackson and Michael A. Rebel. They worked with a coalition of parents, community members, and attorney Denise Morgan, and education advocates who were concerned about the state's funding of New York City schools, which the CFE felt was persistently inadequate.